morning and welcome to Don't Run Out of Money. I'm your host, Dave Seibel. On today's show, we're going to discuss estate planning with estate attorney extraordinaire, Gary Botwinick. Now, I want to read you Gary's full title and some of his accomplishments, just so you know who we're lucky enough to have on the show today. Gary's the managing partner and chair of the Trust and Estate Department at Einhorn, Barbarito, Frost, and Botwinick in Denville, New Jersey. He's a fellow of the American College of Trust and Estate Counsels, a former attorney for the Internal Revenue Service, and a sought-after lecturer, speaker on issues connected to estate planning and related matters. He's been doing this for over 25 years. Welcome. Thanks for joining us, Gary.
Thank you for being here.
Great. Hey, Gary, just to start off, in the world of financial planning, where I spend most of my time, estate planning has become kind of a buzzword when dealing with the wealthy. Can you kind of give us a background on what exactly is estate planning, and is it just for the wealthy?
Well, thanks for the question, Dave. Estate planning is not just for the wealthy. It's not unusual for me to receive a phone call or an email where a client tells me, or a prospective client tells me, all I need is a will. I don't need an estate plan. That's for somebody really wealthy. And the fact of the matter is, that's actually not true, that it's for the wealthy, and just doing a will is an incomplete estate plan. So when we're talking about the estate planning process, we're talking about certainly preparing for one's death through the use of a will. Perhaps there may be the use of either trusts that are created during life or trusts that are established under the will. We're also talking about coordinating non-probate assets. And what I mean by that is, in 2020, you'll find that most of my clients have most of their wealth tied up in assets that don't even pass under a will. For example, it's not unusual for somebody to have a rather large 401k or IRA. And those don't pass under a will. Most people are surprised by that. They pass by a beneficiary designation, which is executed outside of the will. Same is true with life insurance. Also, if there are joint bank accounts, if there are jointly owned titles to real property, those assets may not pass under the will. So when we're talking about the estate planning process, we're getting all of the information regarding the client's assets and determining which assets will pass under the will, which assets won't pass under the will, and implementing a system so that all of the assets pass to the right people in the right way. When we're talking about the estate planning process, we're also talking about coordinating and planning for somebody's disability or a health crisis. So that would include the execution of a power of attorney. It would also typically include a healthcare proxy in a living will, so that somebody is appointed to act on a client's behalf in the event they're incapacitated or for some other reason can't act on their own. So that's sort of the estate planning process. And it's not just for the wealthy, it's for everybody. There are unique situations we see that include having a disabled child, having a child who's a spendthrift. So when we're talking about doing the estate planning, we're talking about all those issues and coordinating that into a plan that makes sense, not just for the client, but for the family.
So this is a really complex topic. And what we find a lot, certainly on the financial planning side, is there's a lot of people that just use a bucket. They put people into certain buckets. How is it done from your perspective? It sounds like everybody's unique, and how do you treat that from an estate planning perspective?
Yeah, so it sounds like, Dave, what you're talking about is there are attorneys out there and services out there that try and be a one-size-fits-all prospect. So that when you go into an attorney who maybe doesn't specialize in this field, they may look to make your situation fit into a document that they had previously drafted for another client.
Right.
All of the work that we do in our office is what I call bespoke. It is customized so that we spend time on the front end with the client, getting to know what the client's objectives are, what the client's finances are, and also to learn about the members of the family who are going to inherit. And by getting those topics on the table and discussing in frank conversations what issues there may be in the family, we always get a better result. So we might ask a client a question that results in a response, well, my son's marriage isn't so strong, so I'm a little worried about that.
Sure.
In those cases, we might suggest certain estate planning techniques, like the use of trusts, what we call purely discretionary trusts, so that those assets do not become at risk for division in a divorce or factored in for purposes of support. So that's sort of the type of work that we do with our clients. We also ask, oddly enough, about our clients' parents. Do you stand to inherit a significant amount of money from your parents? And what impact is that going to have? Are you supporting your parents? Are you supporting anybody else besides your immediate family? What concerns are there regarding your son's or daughter's ability to manage money? We're having frank conversations on the front end. And by doing that, we can customize a plan that fits that client's particular purpose. And they're not always in lockstep. They may have one child who's pie in the sky, not really practical, and another one is very practical. So maybe a trust mechanism might be more appropriate for the one who's impractical, and the one who is practical, that beneficiary's distribution would be outright rather than in trust.
Sure.
So all of this comes from having a great dialogue with the clients and understanding their needs. And that way I can customize a plan that suits their purposes.
Right. So it's very much the same manner that we would create financial plans for clients. And in fact, we usually work very closely with the attorneys on the financial plan and the estate plan. So Gary, let's talk. I know we can get into a conversation about this and get into the details, and you really do have estate planning for maybe the ultra wealthy, where we're talking about estate taxes and things like that. And I'd love to have you back and talk about that on another show. But for the rest of us, what are, at a minimum, what are the documents that we should, that you should be getting when you go to your attorney for an estate plan?
So certainly one of the most important documents is the last will and testament. The last will and testament will govern how the assets pass at death. The last will and testament governs who's in charge when somebody passes away. If you have young children, meaning under the age of 18, and you need to appoint the guardian, that would be covered by the last will and testament. If you have certain specific bequests, you want somebody or charity to get a certain amount of wealth, that's governed by the will. And oftentimes that's where, if you go to a general practitioner, that's where the discussion will begin and end. But in our case, we also go further. So let's take a look at the assets that aren't going to pass under the will. How is the principal residence held? Is it held in the name of one spouse? Is it held in the name of both spouses? Does it pass automatically by rights of survivorship? Are there assets that have beneficiary designations that I mentioned before? IRAs, 401ks, 403bs. These retirement plans become very complex, and if they're not covered in the estate planning process and you rely just on the will, it's very likely that you will not get the right results. The right people might not get it, and moreover, they might not get it in the right way, which could cause an acceleration of income tax consequences after your death. So that's the core, is the will, and then coordinating beneficiary designations to make sure that everything goes to the people, and the right people in the right way. And of course, then, as I mentioned, basic estate plan would include a healthcare proxy, where you're appointing somebody to make medical decisions for you if you can't make your own. A living will, which says what sort of treatment you do or do not want to receive in the event you cannot express your own wishes. And then a power of attorney. A power of attorney is a document whereby you're granting somebody the ability to act on your behalf with respect to your property rights. Now, oftentimes after that, we might consider things like a revocable living trust, which is a popular mechanism to avoid probate. And depending upon the client's particular purposes, we might recommend a revocable living trust. While in New Jersey, the probate laws are rather simple, so we don't recommend them for every client, there are certain situations where they're appropriate. For example, if somebody has real property out of state, Florida, South Carolina, whatever it may be, New York City, that property, that person's estate will need to go through probate in the state wherever the real property is located. If through the use of something called a revocable living trust, which is sort of a will substitute, if we put those assets into the trust, we can avoid probate in those states. And that, in the case of New York and Florida, is very important. So that's really the core of the estate plan and the documents that we'd be dealing with.
So once again, this could get confusing, and that's why it pays to go to somebody who knows. What happens, and I hear this a lot in my practice, I oftentimes come across people who, you know, they say, and I've heard this, I'm not going to worry about a will, they'll figure it out when I die. So what happens if somebody does pass away without a will, without their, you know, estate documents in place?
Yeah, so in that case, we're talking about an intestate succession or an intestacy. And what happens is if you do not have your own estate plan put together, if you don't have a will, for example, then your assets will pass by the laws of intestacy of your specific state. Now, what that means is that a bunch of members of your legislature in whatever state you reside in have come together and decided what's our best guess as to how this estate would be distributed if the decedent, the person who died, would have put together an estate plan. And I can assure you, after reading many, many states' dispositions, they're oftentimes not what your client would have wanted. So that's why it's important that you put your wishes down specifically in the terms of a will. Also, if you have an intestacy, then typically what happens is the court is going to have to appoint somebody to act on behalf of the estate. If you had a will, you'd have an executor and you would designate that person. In the absence of a will, there is typically orders of succession in the state statutes, and either the surrogate or the orphans court or the like, depending upon what state you reside in, will issue letters to whomever it is that is next in line to qualify as the administrator. Now that creates more problems for the family. Moreover, in most states, not all states, there is a requirement to post a bond by somebody acting as an administrator. That means you have to front money to buy an insurance policy to ensure the beneficiaries and the creditors of the estate that you are going to carry out your responsibilities. That can be expensive in larger estates. Even in small estates, it can be expensive. So why bother with that if you can write a will and waive that requirement for an executor? So it does create a real vacuum when somebody passes away and doesn't have a will, especially in that time in between the date of death and somebody being appointed as the administrator. So it's not worth any savings that you think you're going to achieve by not writing a will. You're better off doing it. It will be cheaper in the end.
Great. I have a follow-up to that, but right now we're going to take a break, and we'll be back in a moment.
Medicare coverage can be a very confusing and complicated process. Help is just a phone call away, 856-226-4800. As a licensed insurance agent, I'll assist you in making an informed and confident decision on a Medicare plan that meets your needs, lifestyle, and budget. Call me today for a free, no-obligation Medicare benefits consultation, 856-226-4800.
When did you see the sign?
When I needed to create a better visitor experience.
Improve our workflow.
Attract new customers. That's when Fast Signs recommended Fleet Graphics.
Yeah, now business is rolling in. Get started at fastsigns.com.
What do I want to be when I grow up? Maybe a musician? A veterinarian? Maybe an equestrian? A mommy? Well, why not all these things and more, consider joining me, Dr. V, with friends and colleagues as we explore a wide range of topics together. V is for variety, here on RVNTV.
Welcome back. We're here with attorney Gary Botwinick discussing estate planning. And before the break, we were talking about what happens if you decide you don't want a will, you don't want to put a will together and you're going to leave it to your family afterwards. So Gary, it sounds like that's, a little where, people may not, a lot of people don't want to focus on dying, don't want to focus on talking about wills and things like that, almost because it may jinx them or something, I don't know. In essence, it sounds like it's a little bit selfish, because what you're doing is you're putting a big burden on the people that are left behind. And actually, as I can attest to in certain cases that I've been involved with, it could lead to a lot of angst among the family. So,
yeah.
I guess we can't stress it enough, obviously from your position, from my position, that having, an estate plan, having your documents in place is a must. It shouldn't be an option.
Yeah, it really is something that you should neglect. For example, we were talking about what happens in the event of an intestacy, the absence of a will. It's not unusual for there to be multiple children of the decedent, and then you get into issues where there's conflict between them as to who should be appointed. And it's not unusual sometimes for those cases to require a court hearing and attorneys to be appointed and or to be retained. And it becomes a very expensive ordeal. And look, I get it. It's difficult for many people to discuss this topic. For me, it comes quite naturally. I've been doing this for over 25 years. So what we try and do with our clients is put them at ease and try and explain to them that the process, if you put the pieces together, the process can be very easy and much less burden on the family. But if you don't put the pieces in place, it will create more strife than you could imagine. And it's always better to have a plan in place. David, you and I discuss special situations where it's even more important. So
yes, absolutely.
I'm sure you face that in your business as well.
Yeah, as you know, and this is actually how I met Gary. Was my father and stepmother had been together for a long time. We had we wanted to get their situation reviewed. And like so many other people now, there's blended family. There was, on my stepmother's side of the family, I have two stepbrothers. They had some inheritance money come through there. So we had a lot of issues that, people say, oh, this is simple. But there's a lot of issues that have to be addressed. Gary, and I know you touched on it beforehand, but what are some of those other situations that you may come across in just, I hate the word, use the word the average family, but that you see a lot come across, come through your office, where people may think, oh, we have a very simple situation, but it's not.
Yeah, it's actually quite funny, because we get a call, it seems almost on a daily basis. All I need is a simple estate plan.
Right.
And then once the client comes in, it turns out to be far more complicated than they had anticipated. You touched on one of the most difficult topics, and also one of the most frequent situations we face, which is when there's a blended family.
Sure.
When there's a husband and wife and they have children from prior marriages. It's not unusual for clients to come to my office and they say, all right, we're just going to leave everything to each other, and then when the second one dies, the will should say it's all divided up among all of the children. Well, that may work, but it may not. It's not unusual that when one spouse dies, the children of that deceased spouse may not maintain a relationship with the widow or widower. And then as people get older, they sometimes become subject to the influence of others.
Right.
So you could have a situation where a widow has children of her own, and while the will that was prepared while the husband and wife were both living left everything equally to all of the children, now the child of the widow is influencing his or her mom. Hey, you don't see those kids anymore. They don't call you on your birthday. Why don't we just change the will? And there would be nothing to prevent, in my example, the widow from changing her will.
Yeah, I've
So
seen
when
that
blended
happen.
families come to our office, we always have discussions about utilizing things such as trusts, maybe providing for an immediate inheritance at the first spouse's death for the children of that spouse, so that they're not sitting and waiting for the widow or widower to pass away till they inherit everything. So that's a situation we see on a weekly basis. And then, of course, we have issues where there might be a child who has special needs, and we need to be concerned about an inheritance by that child. What impact will that have on governmental benefits?
Sure.
Should we be utilizing something called a supplemental or special needs trust, so that we can ensure that that child has what he or she needs, but also doesn't forfeit the governmental benefits that they're entitled to? So those two are the most common. Of course, we always have unique situations. I had a situation where a client's child was wrapped up in a drug cartel, and we were very concerned about that, obviously. So we wanted to ensure that any money set aside was going to be protected, not just from the cartel, but also from the child's own undoing. And that's when we utilize trusts and fiduciaries known as trustees who will control those assets and act as surrogates for the parents when they're deceased, to say how those assets are going to be used. So we have all kinds of unique situations. My job would be boring if I didn't have all these unique situations, but I can count every day there's going to be something unique that comes up.
So if you do something long enough, you're going to see just about everything.
That's true.
That's great. So, Gary, as we get further and deeper into the subject, and we certainly will on follow-up episodes, your business, my business, they mirror each other a lot. And one of the things I run into all the time is the do-it-yourselfer. Now, with this subject, it could take a couple different forms, I guess. There's the software packages that you can buy where you can just plug and play. You put your information in, and it spits out a will and some other documents. Or, perhaps go to LegalZoom or one of these other online legal providers. What's your feeling about that? And do you think that this is something that, people can be, for lack of a better way to put it, penny wise and pound foolish?
Yeah, so as you can imagine, I'm not a big fan of online estate planning programs. The thing that they're lacking the most in is the question and the follow-up question. And what they will do is they'll simply ask basic questions, but there's no dialogue going on with the attorney and the client to understand the unique situations that family may face. And every family is unique, and every family there should be a discussion about these items.
Right.
I will tell you that there's sort of a running joke among trust and estates attorneys, basically that LegalZoom has created more work for us than it has taken away, and not just LegalZoom, but other websites. Because clients don't necessarily answer the questions correctly. They don't necessarily cover all of their bases. And as a result, they wind up with a situation that after they're gone doesn't really work. So when we do an estate plan, we're back testing it. All right, let's say that John had died yesterday. We're looking at this plan now. Does this make sense? Does it cover everything we need it to cover? And when you're doing it yourself with the use of one of these software packages or online programs, they don't have that sort of depth that's required. And it seems to me that if you're going to look to save money on something, the disposition of everything you've built over your entire life to save money when you're dealing with that issue, to me, doesn't make a lot of sense. So I would caution anybody using one of these programs that they may want to rethink it, and they're probably better off dealing with an attorney, and there are all levels of attorneys that bill at all different rates, depending upon the level of sophistication required. In my office, for example, we have 3 attorneys that are doing this kind of work, and we all bill at different rates so that we can accommodate smaller or larger estates and make sure that we have the right level of experience working on it, and that a client is not overpaying for experience that they don't need.
Great. So getting back to that, what do you see would be the biggest risk of, for the do-it-yourselfer in putting together their own documents?
I think the biggest risk is probably not executing them properly. So that creates problems when it needs to be probated, not covering all of the bases, and most importantly, I think probably not covering those assets that don't even pass under the will. Clients are shocked when I tell them that we're going to have a will for you, but 90% of your wealth is tied up in your 401k, which is governed by a beneficiary designation. If you simply wrote a will, and it's not unusual for clients to put things in their will, like, not in my office, of course, but I might see a will that says my IRA goes to so-and-so. That won't govern the IRA. The IRA is governed by a beneficiary designation on file with the custodian of the IRA.
So the beneficiary statement, Gary, would trump...
I'm sorry, David, I didn't hear you.
The beneficiary statement would trump anything that's in the will.
That's correct. So beneficiary designation will trump anything that's in a will. A designation on a bank account, it's not unusual for some of my senior clients to put a child's name on the bank account so that the child can help with their banking. But they're surprised to find out that if they have 3 kids and they put 1 kid on the name named on the bank account, and mom or dad passes away, that child, by him or herself, is entitled to that asset, notwithstanding the terms in the will that might say it goes 3 or 4 ways.
Right.
So when we sit down with a client, we're not looking at just the will in isolation. We're looking at an entire estate plan to make sure that all of the assets go to the right parties in the right way. And that's why doing it yourself on a program is not the best way to go.
Sure.
Undoubtedly, it will not ask the questions that need to be asked, and it will not match up the non-probate assets with the ultimate disposition you've carefully planned out.
Great. We're running a little short on time, Gary. I have just 2 quick questions for you. Number one is, how often should should their estate plans be reviewed?
So we typically suggest to our clients that if there is a significant change in the wealth, if there is a significant change in the family dynamic, divorce, death, a child becoming estranged, if there is a significant change in the law, and then typically we're talking about the tax law, and in that case we notify our existing clients, and we also use social media. And then finally, if 5 years has gone by and none of those things have happened, it's a good idea to check in with us.
Great. Gary, I appreciate it. Last for you, if people want to get a hold of you or your office, how do they go about doing that?
So they can contact my office. The phone number is 973-586-4915. My email is a little longer. It's gbotwinick, GBOTWINICK, at Einhorn Lawyers, EINHORNLAWYERS.com. We also have a website, einhornlawyers.com, and you can go on our website and get information about the work that we do. We also have a social media presence on Twitter, LinkedIn, and Facebook. So if you go to our website, you'll find links to all of those items.
Great. Gary, thank you very much for being with us today.
Thank you, David.
You're a wealth of knowledge on this topic, and hopefully you'll come back for more of the same. And I want to thank everybody for joining us today, and hopefully join us again next week for more Don't Run Out of Money. Have a great week.